পঞ্চম আন্তর্জাতিক বাঙালি সম্মেলনের প্রথম দিনের আজকে একটি উল্লেখযোগ্য অধিবেশনের সাক্ষী হতে চলেছি আমরা। এই আলোচনার বিষয় আপনারা জানেন, আদালত রোগ না নিরাময়, কোর্টস দ্য ডিজিজ অর দ্য কিওর। আদালত সম্বন্ধে অনেকের অনেক রকম অভিজ্ঞতা আছে, কখনো দীর্ঘসূত্রিতা, যখন বলা হয় জাস্টিস ডিলেড ইজ জাস্টিস ডিনাইড, আবার তার উল্টো বলা হয় জাস্টিস ইজ হেস্ট ইজ জাস্টিস ওয়েস্ট। কজনের সামর্থ্য আছে এই আদালতের দরজায় পৌঁছনোর, আবার অন্যদিকে এক একটি যুগান্তকারী রায় গোটা সমাজ, গোটা মানুষের জীবন পাল্টে দেয়, সে নিয়েই আমরা বেঁচে আছি। এই বিষয়গুলো আইন, আদালত, সমাজ, নাগরিকের অধিকার, নাগরিকের সুবিধে অসুবিধে, এই সব জিনিসগুলো নিয়েই আজকে আলোচনা হবে। এই আলোচনায় সভাপতিত্ব করছেন বাংলা ওয়ার্ল্ড ওয়াইডের মাননীয় সভাপতি শ্রদ্ধেয় বিচারপতি চিত্ততোষ মুখোপাধ্যায়। ওর পরিচয় দেবার ধৃষ্টতা আমার নেই। উনি বাঙালির অভিভাবক সম এবং কলকাতা ও মুম্বাই উচ্চ ন্যায়ালয়ের প্রাক্তন প্রধান বিচারপতি ছিলেন। এছাড়াও আইনের বহু গুরুত্বপূর্ণ পদ উনি অলংকৃত করেছিলেন। বক্তাদের মধ্যে রয়েছেন মাননীয় বিচারপতি শ্রদ্ধেয় শ্রী রঞ্জিত বাগ। তিনি কলকাতা উচ্চ ন্যায়ালয়ের প্রাক্তন বিচারপতি, কলকাতা নগর দেওয়ানি আদালতের প্রাক্তন প্রধান বিচারক এবং পশ্চিমবঙ্গ জুডিশিয়াল একাডেমির প্রাক্তন অধিকর্তা এবং রাজ্য প্রশাসনিক ট্রাইব্যুনালের প্রাক্তন সদস্য এবং আইনের বহু পুস্তকের প্রণেতা। রয়েছেন এ সময়ের কলকাতার অন্যতম গুরুত্বপূর্ণ আইনজীবী, বরিষ্ঠ আইনজীবী শ্রদ্ধেয় শ্রী সৌমেন্দ্রনাথ মুখোপাধ্যায়, বার অ্যাট ল। তিনি রাজ্যের প্রাক্তন অ্যাডভোকেট জেনারেল। তার আইনের পারদর্শিতার পরিচয় আমরা সংবিধান, বাণিজ্যিক আইন এবং সেই সঙ্গে অন্যান্য বিষয়ের আইনেও আমরা পেয়েছি। তার একটি ব্যক্তিগত পরিচয়ও আছে, আমরা যারা জানি সেটা ভালো, হয়তো উনি পছন্দ করবেন না। ওনার বাবাও হাইকোর্টের একজন অত্যন্ত সুযোগ্য আইনজীবী ছিলেন এবং কেন্দ্রের প্রাক্তন মন্ত্রী। আমি এখানে উপস্থিত আছেন রাজ্যের অনেক মাননীয় প্রাক্তন বিচারপতি এবং বিশিষ্ট আইনজ্ঞ, আইনজীবী এবং আইনের অনেক ছাত্রছাত্রী। আলোচনাটা আপনারা চিন্তা করবেন না, আইনের আলোচনা, সুতরাং ভাষার মধ্যে ইংরেজি বাংলা দুটোই থাকবে। Those of you who can't follow, please don't get disheartened. There will be ample opportunity of communication. Language will not be a bar. আমি এইটুকু বলে শ্রদ্ধেয় বিচারপতি শ্রী চিত্ততোষ মুখোপাধ্যায়কে আজকে সভা সূচনা করার জন্য অনুরোধ করছি।
I was in readiness and continues to be so. First is, which language do I adopt? Do I speak English or Banglish, what do you call it, or Bengali? Well, I'll take the media. I'll do both ways. It's my pleasant duty to welcome both Mr. Mukherjee and Mr. Bagh, or may say Mr. Justice Bagh, to this discourse on court, whether it's a disease or a cure. When having been once part of it, I dare say I can't call myself belonging to a disease profession or profession. But then there are shortcomings, there are reasons which prompt us to ask for immediate change in its attitude, both of the judges who judge and people who are judged. We are looking forward to both of them eminent personalities on the field of law to have their say on the question. But may I say that with regard to the question, the courts, as we know now, is to be kept up because it had replaced the court's judicial system that you know, for reasons both historical and because of necessity. The, the, before the establishment of the judiciary, as we know now, the junior judiciary and the judges in the High Court, of course there is Supreme Court, too soft and too lofty to be talked about here. May I say this again, that with regard to the system, that we have sought a system which had replaced, two kind of courts in this country. I believe whatever, it came to be amalgamated. It's a court which preceded, one which is confined to the bounds of within the bounds of as we call the original Kolkata, bounded by Circular Road on the south, on the Ganges on the one side, because that was the product of a court which broadly was called one of the three latest patent court, established by Royal Latest Patent. But then having regard to the historical fact of having obtained Lord Clive the Devani in 1765, I believe. The rest of the country came to be ruled by the East India Company. It's a peculiar situation. But then, without going into historical part of it, the result of this was there has been certain anomalies in the functioning of the court, the system, which necessitated, both problems and also solution of some of the problems which is attached to what we call the judicial system since 1862. Therefore, there have been, and there continues to be, difficulties in the way of court functioning as you normally call. The court functions now, of course, having a jurisdiction with the High Court in the states at the apex and with the judicial districts divided into district. Of course, not to speak of the Supreme Court, but that's beyond what today's subject matter of discussion. So therefore, the result has been, as I have said, there have been anomalies, there have been system, but the court, and therefore this judicial system that we have in the state or before that in the provinces, there having been an amalgam, both of a part of inheritance from the Mughal, from which Devani had been obtained by the East India Company, and until, of course, the Charter High Court, the Charter used to be called, had been repealed, and the Queen Victoria became the Queen Empress of the entire country. Of course, that's part of history. But then, as I've said, the amalgam has created problems, and the result has been two judicial courts. One which administered the original jurisdiction. As you know, my friend, Mr. Mukherjee, is one of the adornments of that court, I suppose. To a fortune, he's there. And Mr. Justice Bagh, he belonged to the judiciary, came, and then he was ultimately elevated to the High Court. So the divergence between two, there has been amalgam, as I said. The result has been, misgivings on our part, perhaps for the common man about the delay. Secondly, rather complications in the matter of dividing jurisdiction. But may I remind my friends here, the young friends here, that before the Article 226 was even part of the Constitution of India, in its enactment by the Constituent Assembly, the Section 45 of the Specific Relief Act had a limited jurisdiction under mandamus, what we call them, confined to the limits of Calcutta. And as I've said, inconsistencies prevail, and therefore, as the difficulties arise. By and now, the entire legal system, because of the Advocates Act, now it has been made into one for the entire India, one kind of system of judiciary. But then I suppose if you ask about its shortcomings of the court judicial system that you have, perhaps the short answer is shrug your shoulders and say that you can't help it. There's no question of going back to a system which preceded the foundation with the Sir Berners Peacock as the first Chief Justice of India. One thing my young friends might not be knowing, that the one picture which adorns the court number 1 in the Calcutta High Court is of Sir Eliza Impey, who is more known for his notoriety, if I may use the expression, having presiding judge in the trial of Maharaja Nanda Kumar. But then, in his later life as a judge of the Supreme Court of Calcutta, I mean, he had difficulties about extending jurisdiction of its power to arrest somebody outside the original limits. So therefore, Eliza Impey is perhaps, for another reason, is first of those between him and the Governor General of the Lord Hastings had, shan't say tussle, but quite an amount of dispute as to the power of the court to function and extend its power to arrest somebody beyond the original limits of the High Court. So therefore, I mean, as I've said, inconsistencies do remain. But as I may say, the anomalies, the difficulties persist, but there is no alternative at the present moment. Therefore, what we can look forward to reform, make the courts, judicial system as we know, and make the court function better, the people, for it is intended to administer justice fairly and for the best of the interest. But there are other points, as I've said, some of the aspects of the judicial system do need amendments, but not totally discarding the court. It is not a disease, but certainly a rather time old, which requires refurbishing. If I use an expression in relation to a court, I mean, it requires that to be done. So my best wishes for looking forward to a lively debate on the question of the court's functioning. I'm sure neither Justice Bagh nor Mr. Mukherjee would be rather harsh on the criticism of the court. But as I've said, there is no other choice before us. On occasion, we have seen in relation to Justice Bagh that he had to do something unpleasant, but then something he had brought out, which without mentioning what they are, because there's a matter in the political arena, he did something remarkable. The court, for that matter, the judges are capable. And I end by saying that the functioning of the judicial system has been subject matter of criticism, not now, but then even late novelist Bankim Chandra Chatterjee, in his Kamalakanta Daptar, I'm sure some of you, at least the older ones, have read how much critical he had been of the judge, the lawyers, and the one who seeks justice. That was the Gwalini, whose milk used to be drunk by the person. Anyway, these are matters, lighter matters, but certainly that points out that the question of inconsistency, question of corruption, if I use that expression, I mean, they have been there. But don't end it, please mend it. That's all I say. Thank you very much.
Honorable Justice Chittotosh Mukherjee. who is not only presiding over the session, but he is the president of this august organization. Honorable Justice Pradipta Rai, sitting off the dais, Mr. Anindu Kumar Mitro, barrister, senior advocate, and former Advocate General of the state. Mr. Deepak Bhattacharya, senior advocate of Telangana High Court. My co-panelist, Mr. Somendranath Mukherjee, barrister, senior advocate, and legal luminary of our present time, and also former Advocate General of the state. All members of this organization, guests, invitees, and dignitaries, faculty members of some of the law colleges, my dear students, members of the press, ladies and gentlemen. Now, I have decided to make my presentation with PowerPoint, so I have prepared a PowerPoint. Initially, I will show just a glance of areas pending in the courts, and then I will try to project why the people are not satisfied with the functioning of the court. And then I will try to point out various factors very briefly from the point of view of the judges, from the point of view of the government, from the point of view of the members of the bar. And remedial aspect to some extent will be touched at that time during my presentation. Now, cases which are pending in the district courts all over the country is 4,79 lakh something. And pendency of the cases in the high courts of the entire country is 63,47,490. This figure is up to 1st February 2026. Now, pendency of the cases in the district courts of West Bengal as on 1st February is 38,58,437. Out of these 38,35,437 pending cases, 19% are 5 to 10 years old and 19% are above 10 years old. Now, in the Calcutta High Court, pendency of the cases as on 1st February is 1,96,354. Out of 1,96,354 pending cases, 17% are 5 to 10 years old and 39% are above 10 years old. Now, I have made a calculation of the institution and pendency of the cases during preceding last 3 years. And on an average, I have found that the pendency of cases is being increased on an average every year in the district court, 3,51,841. Whereas the reverse is the case in the High Court. During last 3 years, preceding 3 years, in the High Court of Calcutta, the pendency is reduced on an average 17,385. That is a good sign for Calcutta High Court. Now, generally, what is the expectation of the people from the judiciary? All of us know that people want speedy justice. That is the expectation of the people. People do not want to win a case or to lose a case. They don't bother because there is higher forum. But they want speedy justice. And speedy justice is recognized as fundamental right in Hussainara Khatun's case by the Supreme Court, where some prisoners were detained in Bihar jail for 5 to 10 years without trial. Mrs. Hingorani, senior advocate of Supreme Court, brought it to the notice of the Supreme Court, and ultimately they were released. And in several other cases, Supreme Court has given guidelines from time to time. There are plethora of decisions. I will cite one or two, but not in details, just I am mentioning the name. Common Cause versus Union of India and Rajdev Sharma versus State of Bihar. In both the cases, the Supreme Court has given comprehensive guidelines for expediting the disposal of the cases. Now, next, people want that there must be fairness, impartiality on the part of the judge while deciding the case, and judge must adopt the procedure approved by law while adjudicating the dispute. That is the expectation of the people. I will cite many of you, those who are law student or law faculty, they might have heard about Justice Felix Frankfurter of US Supreme Court. He was appointed as a judge of US Supreme Court by President Roosevelt, and he remained as a judge for long 26 years in US Supreme Court. And he is remembered not only for his epoch-making judgments, he is more remembered for the procedure adopted by him for arriving at the conclusion. Because the procedure adopted for arriving at the conclusion is more important than the conclusion itself. Because if the procedure is not followed properly, then the impartiality of the judge will be questionable. Next is promptness in passing orders and delivery of judgment. Every litigant wants that his order must be passed immediately after conclusion of the argument. And in main cases, immediately after main argument, judgment must be delivered. If it cannot be delivered at that moment, then a future date must be notified on which the judgment must be delivered. But in practice, we have seen for the district courts, there is provision in CPC and CRPC that a criminal case judgment must be delivered within 6 weeks. In a civil suit or appeal, judgment must be delivered within 2 months. But in the High Court, in the writ matter, there was no rules or guidelines for delivery of judgment. So in one case, the Supreme Court had to intervene. The name of the case is Anil Rai versus State of Bihar, where the Supreme Court had to give the guideline where the judgment will not be delivered by the judge within 3 months after conclusion of the argument. Litigant public or his advocate may mention it before the Chief Justice, and the Chief Justice will give a confidential note to the concerned judge. If that does not work, even after waiting for 4 months, if judgment is not delivered, then another opportunity will be given to the litigant public to move before the Chief Justice. And even after that, if the things do not work and judgment is not delivered, then the Chief Justice can reassign the matter to another judge for fresh argument and judgment. So that is the guideline given by the Supreme Court, even for the High Court, for delivery of judgment on time, at least within 3 months. Next is promptness in execution of orders of the court and expectation of the people from the judiciary. Now every litigant wants that the order must be executed on time. Now judiciary do not have infrastructure for execution of the order and decree. They have to depend on executives. But the strength of the judiciary lies in the faith of the people in the judiciary. This faith of the people in the judiciary is there. It is not totally eroded. It is still there because the High Court has the power of contempt of court for execution of the court's order. And so court's order must be executed because a litigant public may get the order within 4 or 5 years. But for execution of that order, it may take another 4 to 5 years. So unless it is executed, the fruits of the energy, labor will not be available to him. Now, the factors which are responsible for non-fulfillment of the expectation of the people from the judiciary, I have decided to deal with this aspect from 3 points of view: from the point of view of the government, from the point of view of the judges themselves, and from the point of view of the members of the bar. Now, we have seen that every government, they have apathy to provide fund to the judiciary, particularly the district judiciary. That's why infrastructure of the district judiciary is very, very poor. Even in the High Court, I will not say that the infrastructure is very high, particularly in Calcutta High Court. Judges will have to face many problems for lack of proper infrastructure. So that is from the standpoint of the government. Every government wants that the judiciary should be handicapped so that they can accuse the judiciary and say that, you see, judiciary is not functioning properly. We are doing everything. So they try to pass the buck on the judiciary for the failure of the government on many aspects. Next is lack of expertise of the district judges and lack of expert assistance to the High Court for preparation of budget. Budget preparation is very essential to get fund from the government. Our district judges do not have any expertise for preparation of the budget. And the court staff who get promotion and come to the higher rank from the rank of the lower division assistant or lower division clerk, they do not have any exposure of preparation of budget. So what they do, they prepare the budget by adding 10% of the previous budget. They don't know how to make comprehensive plan budget. Even in the High Court, our honorable judges do not get assistance, proper assistance for preparation of the budget. They get assistance from whom? From the registry. In the registry, senior district judges work. They have no exposure of preparation of budget. That's why budget, both plan and non-plan, is not prepared in a comprehensive manner to get fund from the government. That is one aspect. Now I have to make introspection. I don't think there is any harm in making introspection and criticizing ourselves as a judge. So there is deficiency in the leadership of the district judges to create adequate physical infrastructure and to fill up the vacant posts. I have heard that in the district judiciary, the judges are working with 1/3 working strength of court staff. Why 2/3 not filled up? District judge is the appointing authority of the court staff. District judge is the disciplinary authority of the court staff. So it is the lack of leadership, deficiency in leadership of the district judge to take the initiative to create additional infrastructure from time to time and to fill up the posts. They only look up to the High Court. When direction will come to the High Court, they will work. Otherwise, they will not work, and the things have come to such a pass in the district courts that even the judicial officers have to purchase the cartridge and papers to take printout from their own pockets because there is no fund. Now, attitude of many of the judicial officers not compatible with the justice delivery system. Now, the salary of the district judiciary is increased at least 4 to 5-fold. one judicial officer get initial salary, maybe more than 1 lakh, apart from free internet, free laptop, free SCC online, free AIR online. After getting everything, they look after luxurious car. They look after how to enjoy the life. They don't devote much time for doing the judicial work. I am not saying all of them, but many of them. That's why in the second half of the working day, if we go to the court, we will find that many of the courts are lying vacant. There is no presiding officer in the court. So that should not be done. I worked in the judiciary for long 37 years, from the lowest court to the highest court of the state. During our time, district judges used to supervise whether a particular officer is sitting at 10:30 and at 2 p.m. At least twice in a week, they used to make this supervision and make a note of inspection, which would have reflected in their SCR if they are not doing the work properly. But that is not being done at present, unfortunately. Now, the things have improved. The previous things have now improved. There was no comprehensive planning of the judiciary before 2012. So, comprehensive planning has been started after establishment of National Court Management System Committee. This committee is making, this is at the apex body. Now it is headed by Justice Dipankar Datta. This body is preparing the policy for timely disposal of the cases. Court management means, case management means the judge will have control over the lifetime of the case, from the filing till disposal. He must have control over the case. Only then he will be able to dispose of the case on time. That is court management. So that court management system has been introduced. Policy has been framed so that present justice system may not have more than 5 years old cases. 5 years old cases will be nil from the system. So for the various guidelines have been made, I am not going into the detail. Next is information technology. This is very, very important. Out of the 3 organs of the state, our judiciary has adopted IT lastly. When Justice R.C. Lahoti was the Chief Justice of India in 2005, he envisaged the idea of e-courts project for computerization of the entire judiciary. Before that, computerization was done in a piecemeal way. Even in our Calcutta High Court, computerization was done in such a way that the PCs which were installed in the courts were not connected with the server by LAN. Even the PAs of the judges have no connectivity with the server. They had to collect the judgment in pen drive and go to the server room for uploading it in the server. But under e-courts project, High Court got in cash and kind about 100 crores for upgradation of the IT system, and about more than 85 crores for computerization of the district judiciary. And fortunately, I was the first coordinator of e-courts project in West Bengal and Andaman Nicobar Islands. Justice Sirpurkar was the Chief Justice. He appointed me in 2006 as first coordinator of e-courts project. And I had to take, in spite of best effort, from 2006 to 2010 for installation of hardware, for rolling out of the software. And now, fortunately, at least even in the district court, a litigant public can know what is the status of his case, what is the next date, for which purpose next date is fixed. He can download the judgment and the order from the server. So server connectivity has been done even in the district courts. This is the second phase of computerization which is now going on throughout the country. Next is procedural delay. There is always procedural delay because of hierarchy of forums of appeal. In Bengali we say here here harabo. You might have seen the DA case of West Bengal government employees, which was initially judgment was given in 2016. Ultimately, government could delay the process in such a way that ultimately Supreme Court gave judgment in 2026 after long 10 years. Even then there is doubtful whether the fruits of the judgment will be available to the employees. So this procedural delay can be curtailed if the forum of appeal can be reduced. Some people must be satisfied with the at one stage. Everyone should not be allowed to go to High Court or Supreme Court. Next is establishment of tribunals. What benefit is given by the tribunals, I fail to understand. But Article 323A and 323B were inserted in 1976 by 42nd Amendment of the Constitution. And when under this provision, Administrative Tribunal Act of 1985 was set up, enacted, then we have found that direct SLP could have been filed from the judgment and order passed by the tribunal. And that continued, that system continued 1987 till 1997. In S. Sampath Kumar's case, Supreme Court upheld that provision of the Constitution. But after long 10 years, in L. Chandra Kumar's case, in 1997, 7-judge Constitution bench reversed the decision when the SLP was being piled up in thousands every day. Then Supreme Court had to reverse it. Again, the matter is coming to the High Court. So one additional forum is unnecessarily created, which is again creating burden on the High Court. Instead of establishing the tribunals, the strength of the High Court could have been increased. Number of judges of the High Courts could have been increased. That would have been more beneficial for the litigant public and also for the system, justice delivery system. Now, one, I have seen it in various seminar and symposium that the government is in the habit of enacting legislature. Legislation is being enacted both by the state government and by the central government. Who will ultimately enforce it? If there is a provision for offense, then ultimately it will be enforced by the judicial magistrates. So there is no research, no provision for creating or establishing additional courts when the new legislation is coming into force. And thereby, additional burden is created on the already overburdened judicial magistrates. Those who can deal with 500 cases as per report of the Law Commission, most of them are dealing with more than 30,000 cases. So it is impossible for them to give justice. This aspect should have been taken into consideration by our legislatures. Next, very unpleasant comments, but sometimes unpleasant comments are necessary, as I have told, for self-introspection, for betterment of the system. that is resistance of members of the bar to any kind of reform to the justice delivery system. We have seen that the members of the bar, not all, but some, and they ultimately rule. And they ultimately decide the fate of the rest of the members of the bar. They go on siege work on drop of a hat. But the Supreme Court has given guidelines in plethora of decisions, starting from Mahavir Prasad Singh's case, Raman Services, Common Cause, that a member of the bar who has taken brief from his client cannot do the siege work. Even the Supreme Court has threatened to invoke contempt of court, but that is not practicable. So ultimately, siege work is going on. And I think the members of the bar go on siege work when they can't ventilate their grievances before appropriate forum, or they do not get the remedy from the appropriate forum for the grievances. That's why they go on siege work. That is still going on. Again, I have already pointed out that more than 3 lakh cases are being added to the arrears in the district courts in West Bengal every year. So what is the remedy for reducing the arrear? The remedy is to adopt the alternate dispute resolution mechanism. Otherwise, there is no other remedy. Alternate dispute resolution includes mediation, which is very effectively being done in our Calcutta High Court, but it is not so effectively done in the district courts. But majority members of the bar, except those members who are in the government panel or government GP or PP, except these advocates, most of the advocates oppose ADR like mediation and Lok Adalat due to imaginary fear of professional loss. They think there will be professional loss, but ultimately there will be no professional loss. If they can get their professional dues, they should participate. And there is lack of understanding. They can't comprehend properly what is the benefit of ADR and how reducing the ADR will help them to earn better professional advantage. Lastly, I will say that in the high courts, perhaps our strength is, sanction strength is perhaps 72. Am I correct, sir? And the working strength is now 44. Out of 44, 6 judges will go to Jalpaiguri bench when permanent circuit bench is set up. 2 judges will remain in Port Blair on circuit. So only 34 judges will be available to deal with the more than 1,97,000 cases. When there is any vacancy, there is one SOP, standard operating procedure, how to fill up the vacancy. So it is the duty of the Chief Justice and the members of the Collegium to recommend the names for appointment of the judges. Now, whether the Supreme Court will do it or the government will do it should be left to them. But the groundwork should be done by the Collegium members and the Chief Justice on time, as per SOP, which is not done. So, this much I wanted to say and share with all of you. Thank you very much.
It was probably my 5th appearance. My learned senior, Dipankar Ghosh, had vanished. Mr. Somnath Chatterjee was on the other side. And I was quivering. Justice Mukherjee realized my state and said, "Why are you nodding so much?" So I said, in fear. And we lost that case. It was a bad case. But that was my first appearance before him, and probably, I think matters improved thereafter, but the first appearance before Justice Mukherjee was never to be forgotten. And since Mr. Anindya Kumar Mitra is here, I must acknowledge that all those late nights at his chambers, even before he'd become a senior advocate, I really learned the art of drafting. And he had this amazing ability to be told the facts and get ready in a matter, then and there. And there was one draft followed by 2 corrections, 3 corrections. But at the end of the day, and those days we could move court applications, the drafting would be concluded at about 2 a.m. in the morning, and at 10:30 we were moving for ex parte relief. It doesn't happen today in the High Court. And the reason it doesn't happen is because judges no longer have confidence of not only themselves, but also the lawyers. Those days, I think there was mutual respect. Judges would trust the lawyers, and in turn, the lawyers would trust the judges. But now let's get back to today's time data with regard to pendency of cases. In fact, this data quite often leads us to hear fairly unpleasant things about the judiciary in social gatherings. And it hurts me as a lawyer and many of us present here who are lawyers or aspire to be lawyers. You'll find quite often that litigants' cases are not heard for years, and therefore it is not uncommon to hear the common man commenting on the huge pendency of cases and inefficiencies of the justice delivery system. This in turn has resulted in the judiciary being blamed. Quite frequently, the general public remark on the courts deciding cases involving the rich on a priority basis, while the cases of poor litigants languish in the records of the court. All in all, and this is really worrying, it has eroded the confidence of the people in the judiciary. The question to be posed is whether the judiciary alone is responsible for this state of affairs. Now, in the justice delivery system, according to me, there are actually 4 stakeholders. One, the judiciary itself. Second, the central and state governments. Third, the litigants. And fourth, the lawyers. Now, I am not going to get into a big analysis of the role that lawyers have played or the litigants have played in the courts being talked about as a disease. But 5 points I wish to make apropos lawyers. Adjournments. The prayer for adjournments are made as a matter of course, and sadly the courts grant adjournments as a matter of course. And when are adjournments generally taken? One, where the lawyer is defending a bad case or is not ready. This is known to all. Lawyers have also encouraged filing frivolous litigations because they see litigative resourcefulness of a litigant as a way of ensuring that the litigant who's engaged that lawyer is able to put forward a position which prevents enforcement of rights, and this happens in most cases for the state. In fact, lawyers appear to be primarily concerned with monetary rewards rather than assisting the court in the resolution of the case. Some lawyers, when you meet them, where they introduce themselves as lawyers, you might ask the question, where did he get his degree from? It happens quite often. Litigants. There are many who file cases against political adversaries to settle personal scores. And in these cases, valuable judicial time is wasted, and quite often the state machinery is used and taxpayers' funds is lost in such frivolous litigation. Many litigants feel entitled. They want their cases to be heard in priority to others. This results in judicial time being wasted by repeated mentioning of a matter to have some kind of priority in it being heard. And third, an NUJ student who introduced me to this term, he's sitting here, Ridhaditya Ghosh, said litigants have something known as a jackpot syndrome. Inflate your claims. Somebody will come and settle, or will back off. And this is more so in the case of government, cases against the government. Government may put up a lawyer who cannot defend. And there are a whole lot of arbitral awards which we can look at where unbelievable claims have been allowed. And with the present policy of non-interference with arbitral awards, many have slipped through the net. But I think the biggest culprit are the central and state governments. And I treat them as a class apart when I talk about litigants. Quite often, and here I just want to enumerate a little bit of experience as the Advocate General of the state. Officers dealing with the case quite often have no knowledge of the facts or the law. You have to sift through the files. A particular dispute might have been lingering for 10 years and has now come to court for final hearing. They are of no assistance. Second, they have to listen to their political bosses. If they don't, and they take a stand which is correct, there is always a fear of inquiry. There is always the fear of being transferred out. In fact, many officers are told to litigate by their political bosses so that the dispute is never resolved. Then we have the administrative fronts. There is a reluctance to develop infrastructure for the judiciary or by way of making funds available. There's no upgradation in technology. And what I discovered was that any physical infrastructure that needed to be built, one had to go through the PWD, who quoted the highest rates, which immediately made the judges in the committee think, my God, it costs so much. Is it really worth it? But this is in reality the position. the central government also sits over recommendations made by the Supreme Court for appointments in the judiciary. This has resulted in vacancies not being filled up. And lastly, the state panel of advocates, entry through one door, exit through another. Merit has literally no role in the appointments. It's all on the basis of political affiliation. Lastly, I come to the judiciary on this. Clearly, they are overburdened. The number of cases that are being filed today have increased manifold than what they were in 1950. Members of the judiciary are also overburdened with administrative work, because whenever they ask for something from the governments, there is a reluctance to make that available to the judiciary. Though the government is aware that the judiciary needs this assistance. And sadly, I would say that that happens because political dispensation all over India today has very little respect for the judiciary. It's a really sad state of affairs, because otherwise there's no reason why budgetary provisions cannot be made and funds released. It cannot be denied that there has also been corruption in the judiciary. And one other aspect I need to say, in fact two, is the delay in delivering judgments. I was telling Justice Mukherjee today that sadly in our High Court there are some judges who have reserved judgment in what we refer to as Order 7, Rule 11 case, which is basically that the plaint that you file does not disclose a cause of action should be rejected straight away, has been pending for close to 4 years. Mr. Mitra and I, we are doing a contested case which is known as the Birla Lodha suit. He raised an objection on the admissibility of a document while I was cross-examining. That objection was heard, and we were told by the learned judge that the order will be delivered within a week. We were also asked to give notes of submissions on the issue of objection. That was about 2 years ago. Judgment has not been delivered. Now what do we do? And each time we wish to mention the matter, it will be ready in a week. I have looked at it. Now this is the sad thing. And I see a lot of students here. Remember, when you're joining the profession, you're going to face this. So you must really love the subject, or you'll run away from the profession. Or you must love litigation. Should give you satisfaction otherwise. And lastly, sitting late and rising early on a daily basis. It's happening. And here, as Justice Bagh said, lawyers have made it even worse by passing resolutions. Now they do not say cease work or not to attend because of the new recent Supreme Court decisions. Now they say no adverse order to be passed if both parties are not there. Now, I actually look forward to such resolutions because I know that in several cases, my other side is also there and is willing to work, we can go and conclude the hearing in the matter. Because there's no cease work resolution, there's no not to attend resolution. Do not entertain if both sides are not there. Or do not pass an adverse order if both sides are not there. This is unbelievable what is happening. Now I would like to say we can mend and we must mend the justice delivery system. Now the first set of measures that I've thought of I'll talk about the judiciary first, is first are ad hoc measures. We need to appoint ad hoc judges. Now, if they are retired judges, they should not be the ones who've reserved judgment for 5 years. There has to be a selection there. We could also look at senior advocates doing some public service. Appoint them for a year and see how they perform. Single judge. All their orders should be appealable. I feel I'd volunteer to do it, and I know Mr. Mitro would. I've done 2 arbitrations before him, he's finished them in 5 sittings. Second is delay in appointment of judges. That has to be addressed. Either it needs to be codified, that within a particular time that has to be done. Or orders of the Supreme Court have to be enforced. The determination given to the members of the judiciary in the Supreme Court should not be changed overnight when the orders of the Supreme Court were sought to be enforced. Now, all of you might be aware, Justice Sanjay Kishan Kaul, who was a classmate of Justice Chandrachud at St. Stephen's College, he was the number 2 in the Supreme Court, and he was hearing these matters relating to appointment of judges. And there was a judicial order as well that you need to appoint within a particular time. 7 occasions the Attorney General had taken time, and he had said next time round if it's not done, he'll issue a rule. Next day when the matter was due to appear, counsel appearing, one of them was Mr. Kapil Sibal, found that the matter was not in Justice Kaul's cause list. So he went to mention the matter, and he was told, you must inquire. He inquired, is there any particular reason why the matter is not appearing? He says, you better put that question to the master of the roster. Now what does it show? Judiciary had an opportunity to correct, and the then Chief Justice ensured that it wasn't. Third, we must be very careful with regard to the judges who are appointed. The persona is what is important. There's so much opacity in the appointments. They must fulfill a criteria. Now we have judges. Calcutta High Court suffered one, Justice Karnan, who I believe is still occupying a flat in Rosedale. Now what does it say about the judiciary? The recommendations start with the High Court. This I'm talking about the High Judiciary, and then the Supreme Court, and then the government. Deserving people are not appointed. And we have these examples. And sadly, these judges, they think are fit to be in only one High Court, which is the Calcutta High Court. The political dispensation is happy with it. Lawyers are busy passing resolutions for cease work. With Karnan there, it gives you an opportunity to have more resolutions. So it's very important that we appoint right people. And here I want to say one more thing. With the multiplicity of legislation all over, there has to be areas of specialization. And judges should be appointed and given determinations, keeping in mind domain specialization. Otherwise, quite often we end up arguing a case relating to securities before a learned judge who has probably only invested in a fixed deposit, because he's not made himself aware about securities. Or maybe he's been risk averse. And to cap it all, now we talk about dematerialized stock and shares. And they don't see a piece of paper, which is the share certificate. They are completely at sea. Arbitration matters, commercial matters. Many judges find it very difficult to cope with. Now, in normal course, if we had the right appointments, the fact that they were not familiar with this branch of the law, they'd pick it up in 2 days. One matter being told, one matter before them, a heavy matter, being told what they need to read and look up, they'd be in a position to do it, provided that they had been selected for the right reasons and had average intelligence. But today, it's quite common to find judges with the meanest intelligence. And here again, I borrow the language from a judgment which says when a fairness of a scheme for merger or demerger is to be looked at, it should shock the conscience of a person of the meanest intelligence. So in the face of it, it should appear to be unfair. Now, certain procedural matters. Here we need to enforce limits on adjournments, increase the use of summary trials. In many countries today, every matter can be decided on the basis of what we are used to, Order 37 and Chapter 13A. And most importantly, we need to put a limit on the length of judgments, especially by judges of the High Court, and the Supreme Court. It wastes time, it's unintelligible, and we have a plethora of quotations, possibly given by law clerks, and the reasoning is under the circumstances. This is what we really need to avoid and address. Now the central and state governments, they need to know when to give up on a litigation. Quite often, they continue litigating the same issue in different courts. There has to be a policy on this. There are judgments which say that if a stand has been taken by the central government in one high court, it cannot be changed in another. But they keep changing it. Or they keep re-agitating a point which has been decided in one high court. Now, today we have a directive for efficient and effective management of litigation by the Government of India. Now, it says a lot of things, but I don't think it's been put into force. There has to be an objective criteria to select the state's panel of advocates at all levels. Otherwise, things are going to get worse. Lawyers must also know that they have an ethical duty to assist the court, because they are, at the end of the day, officers of the court. Most importantly, we need to make the profession more diverse so that we uplift the disadvantage and improve the results of the judiciary. For litigants to have their lived experiences represented in those who represent them would lead to courts granting relief that is more nuanced, specific, and ultimately more effective. We talk about, quite often now, the representation in the Supreme Court. Which state has a representation? Which state doesn't have a representation? All this is because people from every part of India must know that when we come up to the highest court, we have one of us. Similarly, litigants should also be able to approach lawyers who they can look at and trust as one of them. Whether it's the district judiciary, whether it's the higher judiciary, this has to be done. Now, I think the time has also come for the inauguration. I should not put people to sleep. So, and since I am advocating time limits, I must end it here and hope and trust that it will make what I said today would help the students, actually more than anybody else, to think about ways how they can improve the justice delivery system in this country and in this state. And I'm happy to get suggestions. If not today, later is fine. And I don't know if people know here, there was I think, a seminar on judgment writing. Am I right? Competition, yeah. A competition on judgment writing. I wonder how many judges attended. That was at NUJS, and I had the privilege of supporting it. The NUJS students are here. They can indicate some point of time how it went. I'm told it went well. Thank you very much.
Thank you very much for very helpful speeches and erudite that. And may I end with a prayer and not a prayer? Elomola kore dema lute pute kai. Thank you very much.
Thank you very much, ladies and gentlemen. You have heard the bench and the bar both, and which has given a wide spectrum of real-time situation of the judiciary in India, along with the remedies. I would like to request the President of Bangla Worldwide to kindly hand over the mementos as a token of appreciation to Honorable Justice Bagh and then Mr. Mukherjee. On behalf of Bangla Worldwide, we thank all of you, all the speakers, for sparing your valuable time and enriching our experience. Thank you very much. We come to a conclusion of this session.